Hello, everyone. Welcome to our event, The Election Reform Agenda, a deep dive into H.R.1, where we will be discussing the most pressing issues on election administration that are shaping our democracy. This event is being recorded and will be available on the websites afterwards. My name is Carla Eckhart, and I'm the Executive Director of the Stanford Center on Philanthropy and Civil Society, where we support scholars in producing quality research that informs policy, social innovation, nonprofit, and philanthropic practices. Over the course of this series, we will be and have been joined by a rich mix of experts on the topics in discussion. Today's panel is going to be discussing gerrymandering and will be led by Nate Persley, co-director of the Program on Democracy and the Internet at Stanford PACS and the Stanford MIT Healthy Elections Project. I will turn it over now to our partners for this event, the Center on Democracy, Development, and the Rule of Law, and the Associate Director for Research, Didi Kuo. Thanks so much.
Thank you so much, Carla, and thank you all of you for joining us today. This is the third in our series on H.R.1, the For the People Act, and we have a panel of 4 amazing lawyers to discuss partisan gerrymandering and the gerrymandering components of the bill. In order of speaking, we'll start with Michael Lee, who is Senior Counsel of the Democracy Program at the Brennan Center for Justice. Then Ruth Greenwood, Co-Director of Voting Rights and Redistricting at the Campaign Legal Center. Then Nicholas Stephanopoulos, Professor of Law at Harvard Law School. And we'll conclude with Benjamin Ginsburg, a retired Republican election lawyer and an ongoing lecturer at Stanford Law School, before we open it up to Q&A. If you have any questions, please enter them into the Q&A box at the bottom of your screen, and also follow us on Twitter at #electionreforms. Thank you. We'll begin with Michael.
Great, thank you for having me, and I'm going to share my screen and try to do so efficiently. You would think after 9 months of the pandemic, I would have this like seamlessly down, but it's not quite so seamless, but I will nonetheless. So there, hopefully that's good. I'm going to talk about the components of H.R.1 because it's a complicated piece related to redistricting, and I'll do a little bit of table setting. And what I want to do is first, though, start with the redistricting landscape for 2021 and 2022 without H.R.1, because it's stark. Despite a record number of reforms that passed last decade and wins that resulted in divided government in a number of key states like Wisconsin, single party control and the drawing of congressional maps remains the grim reality for most states this upcoming cycle of redistricting. All told, Republicans will control the drawing of 181 seats with the potential to draw 188 seats if legislatures in Utah and Iowa override advisory commissions. It's a little better than 2011 when Republicans controlled the drawing of 213 seats, but still a massive advantage compared to Democrats who will control the drawing of just 49 seats, 74 if the New York legislature overrides that state's advisory commission. And the point that bears mentioning here on this slide is that it is single party control more than anything else that correlates to whether a state will have politically or racially discriminatory maps. Now, what would H.R.1 do to fix this? Well, H.R.1 is a package of reforms which work together in tandem to make the process less likely to be gamed. And they built very strongly off of reforms that were successful in California, but also other states. And it's important to stress the tandem aspect of reforms, because if you work on redistricting reforms, as many of the people on this call have, you know that when people get started on this, they oftentimes think that there's one key thing that you need to do. You need to find the perfect non-manipulable map drawer. You need to have the perfect rules that can't be manipulated. And what H.R.1 does is it recognizes that in each of those components, there can be failure. And what it tries to do instead is build a system of checks and balances so that even if you, for example, got a rogue commissioner on the commission, that commissioner can't derail the whole of the process. Likewise, if the commission itself goes wrong, there's a judicial remedy and the like. And so the components of H.R.1 are, first of all, there are new uniform national rules for map drawing in every state with more than one congressional district, and these criteria are prioritized in order so that there's not a lot of times in existing law, it can be unclear. The criteria themselves conflict, and unless you have them prioritized, that can be an opportunity for manipulation. Likewise, there are enhanced transparency and public participation requirements, so that maps have to be unveiled well in advance. The public will have a chance to comment on them. The public will have the chance to submit alternative maps. And then there is a judicial remedy if something goes wrong, and we'll talk a little bit more about all of these components in a minute. That includes fast tracking of redistricting cases. Related to that, H.R.1 would abrogate the legislative privilege that lawmakers oftentimes use to hide the behind. And then maps would be drawn by an independent commission. And this commission has a number of features designed to ensure that it truly is independent. The selection of the commissioners would be under the auspices of an independent agency. There would be rules for conflicts and qualitative screening of commissioners to make sure that they're well suited to serve on the commission and truly independent. And then to approve maps, you have to win pan-partisan support. So the commission would have Republicans, Democrats, and independent and third-party members, and you have to, out of those three buckets, win at least some support from each category in order to pass a map. So it's not like Democrats and independents can get together and screw Republicans or any other combination. And then there would also be a ban on mid-decade redistricting, like you saw in Texas in the first redistricting cycle of this decade. Now let's talk a little bit about the statutory ban on partisan gerrymandering. What this ban does is it would target extreme partisan gerrymandering, situations where maps are wildly drawn to favor one party or the other. If you think about the 13-5 map in Pennsylvania or the 10-3 map in North Carolina, both of which gave Republicans an outsized advantage in states that are 50-50 at a statewide level. It would prohibit any map that unduly favors or disfavors a political party on a statewide basis. And in doing this, it looks at effect, not intent, which is a protection which comes in there, to make sure that well, first of all, if you have a bad effect, you don't really necessarily need the intent. But then secondly, it's designed to prevent spurious challenges to VRA districts or to other coalition districts where communities of color are electing candidates of choice who typically tend to be Democrats. And so it's designed to protect the ability of communities of color to elect. This measure looks a lot like a lot of the partisan gerrymandering cases that were litigated both in the state courts and in the federal courts last decade. It's key to understand that it doesn't include district-specific claims or incumbency protection claims. And again, it's leaving some stuff on the table, but it's also designed not to have a bunch of claims brought in kind of a gray area, many of which would be brought about minority opportunity districts or coalition districts. So this is the partisan fairness measure under H.R.1 and how it would work. You'll see that it looks at alternative plans. It looks at the durability of partisan bias. It does exclude any partisan bias that results from compliance with the Voting Rights Act or the Constitution, or the enhanced protections for communities of color. The map drawing rules. So it's a fairly streamlined set of map drawing rules. The number one is that you comply with the US Constitution, then you comply with the Voting Rights Act. After that, there are enhanced protections for minority ability to elect districts after that. And the last rule is that you try where possible to preserve communities of interest, which are broadly defined and left a lot to the discretion of the commission. This is the community of interest rule, which is borrowed very closely from language in California with a few tweaks to better fit the nation. Let's see, public participation and transparency. All of the data related to maps would have to be made publicly available and in multiple languages where required under the Voting Rights Act. The public would have the opportunity to submit maps. The public could comment on maps. Commission meetings would be streamed online and on TV, made available public access TV, and they would be archived as they are in California, so you can watch them, well after the fact. And perhaps most importantly, there would be a report required before a commission could vote on a map, analyzing the partisan fairness and the racial equity and the other the compliance of maps with other criteria before the vote. So they would have to do a detailed analysis, addressing the comments they received and addressing why they made the choices that they made before they voted on a plan. Let's talk about the commission. The commission is, as I said, very closely modeled on what the commission in California. It's a 5-5-5 commission, 5 Democrats, 5 Republicans, 5 independents or third-party members. There are multiple measures to ensure demographic and geographic diversity. The commissioners are selected by a process run through a nonpartisan agency. What constitutes a nonpartisan agency is defined in H.R.1. The nonpartisan agency would screen applications for conflicts, assess applicants for their skills and impartialness, and independently assess whether somebody actually is, for example, an independent, or whether they're really a Republican who just says that they're an independent. And they would have to do interviews with the commissioner applicants. All of this would be public. At the end, there would be, the way it works is after interviewing all the applicants, there would be 12 Democrats, 12 Republicans, and 12 other in a pool. The first 2 in each pool would be selected randomly, and then those 6 would select the remaining 9 and try to use those picks to balance out the demographic and geographic diversity of the commission. The result again is 5-5-5. To pass a map, you need support from a majority of the commission, so 8 out of 15, but you also need at least 1 person from each of the 3 buckets, 1 Democrat, 1 Republican, and 1 independent. Functionally, if all Republicans voted together, you would also need at least 2 commissioners from one of those buckets. If there's a deadlock, it goes to a 3-judge panel, either in DC or the state capitol. Court would be required to follow the same rules. Once a map is approved, either the US Attorney General or any citizen of a state aggrieved by a map can challenge. There's a right to attorney's fees. Those cases also would be heard by a 3-judge panel. And the Supreme Court would be ordered to expedite those cases. And again, there's no legislative privilege. Right now, all of the provisions in H.R.1 related to redistricting don't take effect till 2031, in part because the process outlined in H.R.1 is a very lengthy one. It takes about 18 months in full to run, 9 months, up to 9 months for selection of the commission, and 9 months to draw the maps. And that obviously doesn't work for 2021, 2022. I think there's a general realization on the Hill that something needs to be done to fix this. There are a couple of options that could be done. One would be to separate out the criteria, some of the transparency and publication, public participation requirements, and enhanced judicial remedies, and let the commissions take effect in 2031. The other would be to see if you could streamline the commissions, at least for this cycle, perhaps having something slightly less independent. There is a window of time to do this because of delays in the census data, but not that much because you're also coming up on election-related deadlines, which, unless those move, things really have to be done pretty fast. So with that, I am going to turn it over, I think, to Ruth.
That's right. Thank you so much, Michael. Now to Ruth Greenwood.
Hello, thank you for having me, everybody. I am going to talk about why we should pass H.R.1, why it is fabulous. So it's a pretty easy task. I'm going to go over 3 areas, and then I have a section specifically for why Republicans should support this and specifically why Democrats should support this. So to start out, as Michael explained, I'm going to essentially look at why we should support the redistricting in terms of the powers that it gives, the process that it uses, and the people that it uses. So in terms of the powers, 2 of the key criteria that get included are protections for communities of color when they vote in concert with other voters. That would be a protection that goes beyond current protections, and I believe would also stand even if the current Supreme Court wants to do what it's been asked to do in the most recent Bronovich case under Section 2, which is to strike down Section 2 of the Voting Rights Act. So in order to protect communities of color across the entire country, this would be a powerful step. But the other thing that Michael mentioned that this does is that it stops one of the most pernicious problems that we have seen in the recent decade of redistricting, which is to ensure partisan fairness. The language that's included would give litigators like me an angle to go into court and look at some fair way to judge whether a map that advantages one party has gone too far. As Michael said, it's not looking at an individual district, it's not looking at incumbent protection, it assesses partisan fairness on an overall map, it's like plan-wide basis, and it asks to use accepted measures of partisan fairness from the literature. It is incredibly clear, and it is also something that is the political scientists are able to put in numbers and data and tell you what is going to happen. Now, many people may think, well, how can you really know how people are going to vote? Perhaps if you're on this, you've come past that myth and you accept that there are a lot of people that are very partisan, and we can now identify where they are with surgical precision. And the map drawers do that, and they know how districts are going to turn out. In the last decade, I was one of the lawyers suing Wisconsin State Assembly plan for being a partisan gerrymander, and when we got their files, they predicted exactly what would happen in 2012 when they planned out drawing the maps. And now we get to the end of the decade, and still, in that case, Republicans have more power than they should have, given how many people are voting for Democrats. And in the other state, just below in Illinois, where I used to live, Democrats maintain control no matter what Republicans do. And so to get partisanship out of the process would be an absolute revolution. We know that the Supreme Court will not step in without legislation like this. The Supreme Court is very clear. It considers partisan gerrymandering to be a constitutional harm, except also to be a political question that they will not step in and police, unless there is language like this that can be used. So that's to me, one of the most important reasons is we are protecting communities of color and we are preventing partisan unfairness. The other huge development of H.R.1 is to have independent redistricting commissions. And Michael went over to you what it means by independent and how they've tried to set up the system to make sure that it's not just one side running away with doing whatever they want. You need both sides to come together to be able to get maps passed. And if not, it goes to a federal judiciary with very clear criteria for what they have to do to draw plans. We know that independent commissions tend to lead to better outcomes. And when I say better outcomes, what I mean is you get more alignment between the people who are voting and the people who are in power. So even if democracy isn't your favorite thing, even if what you really care about is environmental policy or immigration policy, to the extent that you can garner the support of a majority of your fellow citizens to agree with you, at the moment, in many places, you can't actually get your congressional delegation and then ultimately the House to vote with you because of the gerrymandering that has occurred. This would be a step forward in terms of democracy, but also in terms of all the policies that the federal government is in power of. And then the last thing that is really good, and this is more if you actually do care about democracy for the sake of democracy, which is this would involve people in the process. The idea that you can't just, well, let me tell you what they did in Wisconsin. They went across the street from the Capitol. They went in a locked room where even members of the Republican Party delegation couldn't get in. There were very few amount of people. They produced a plan and then they rushed it through really quickly. What this process would do would make sure that people are allowed to look at the maps, to comment on the maps, to explain how they would affect their communities and actually involve people in the democratic process. Now, this is a lot harder than drawing a gerrymander. Drawing a gerrymander is not so hard. You just get, a bunch of political data and whip it up for one party. But if we actually want to ensure that people are involved and people have a say and communities are protected, that's when we actually get to have some sort of robust discussion of democracy, which I think would be a very productive way to channel some of our frustrations that have been on show in the last month. Okay, and lastly, I'm going to talk to Republicans and Democrats. So Republicans, hi, why should you support this? I'm going to start out with an argument that did not work in healthcare, but you thought of this first. So Arizona and California were the first people to get independent commissions. They were backed by Republicans. In California, famously, it was Governor Schwarzenegger who wanted to stop all of the Democratic gerrymandering. And so start out with, own your idea. This is great, let's do it. The second reason to do it is because it's extremely popular. The Campaign Legal Center where I work did a poll in 2019, and they found that both Democrats and Republicans, that a majority of both sides would support partisan fairness in plans, even if it meant their party would get less seats. They actually want fairness. So to the extent that all of those people out there who'll be voting on H.R.1 and S.1 want to do what the people want, this is very popular. And I guess the other thing I would say to Republicans is we don't know where we're going to be in 2030. In 2002, the Ohio Democrats rejected movements to get an independent commission because they thought, we're in power, we're going to be in power forever, we're fine. And come 2010, was not the case. So federally, Republicans, don't be like the Ohio Democrats of 2002. This is your chance to not let Democrats come back and gerrymander like crazy in 2030. Okay. Talking to my Democrats. The odds are not looking good for you this cycle. You saw what Michael Lee put up there. That was a big map of the country, and lots of those states were red. That means Republicans are in charge and they can draw gerrymanders. Now, can you fight back by also doing gerrymanders in, Illinois, possibly New York, by overriding the commission? Sure. But then you're probably just going to end up with a bunch of safe seats for both sides, and actual people out there who care about democracy and who care about issues are not going to be able to vote to change who is in power based on changes in their views. And if you have people who are completely unaccountable, we see a host of problems following on from that. Now, even if this only is something that gets adopted for 2030 Democrats, I know I told the Republicans that you're going to have, you might have power in 2030, you might be able to gerrymander, but what if you don't? What if the Republicans have power? So maybe you want to be ready to have a fair process so that it doesn't matter who is in power. We actually have the voters have a say in how our democracy functions. Thank you.
Thank you so much.
I think I'm handing over to Nick.
All right, Nick Stephanopoulos.
Great, thanks very much, and hello everybody. So I think I'm supposed to be the liberal academic gadfly on this panel, supposed to be the one criticizing H.R.1's redistricting provisions from the left. And I'm happy to do that because I do think that H.R.1 could be improved. I think the bill could do an even better job preventing gerrymandering and other line drawing abuses. But I want to be clear at the outset that I strongly support H.R.1. If it were to become law, even in its current form, I think it would be the most important ever and the most positive ever congressional regulation of elections. In my view, it would be an even bigger milestone than the Voting Rights Act in 1965 or the Federal Election Campaign Act in 1974. It's that big of a development when it comes to the structuring and regulation of American democracy. With respect to redistricting in particular, H.R.1 would enable the US finally to catch up with the rest of the developed world by taking politicians out of the line drawing process. Not many people know that politicians used to design districts in Britain, in Canada, in Australia, and so on. Really all the countries in the world that use single member districts. All those places switched to independent years ago and thereby brought an end to their histories of gerrymandering, which once upon a time were just as bad as ours. And I think it's time that we caught up with all these places. So that said, how could H.R.1's redistricting provisions be strengthened? I'll mention several proposals here. First off, and this covers some ground that Michael also went over, I think all of H.R.1's reforms ought to be made applicable to the current redistricting cycle. They shouldn't be deferred until 2030, as the current language of the bill does. In my view, the price of another decade, another lost decade with rampant gerrymandering, with maps that subvert and distort the will of voters, is way too high. Does this mean that the line drawing process by commissions would have to be accelerated? Yes, it does. So let that process be accelerated. We know that if they have to be, district plans can be drawn virtually overnight. And so if now, because of the pressure of the calendar, maps have to be drawn in fewer months rather than more months, that's still plenty of time to do it. And I think it's a small sacrifice to pay, given the enormous payoff of a decade without partisan gerrymandering. Number two, and relatedly, if it really isn't feasible to set up commissions for the 2020 cycle, then at the very least, all of the line drawing criteria should go into effect right away. And of these criteria, the most vital is the partisan fairness criterion, because in the absence of commissions, in the absence of structural reform, that partisan fairness criterion would be the only protection against gerrymandering in this cycle. Now, that partisan fairness criterion wouldn't be nearly as effective without institutional reform as well, but it still would do something substantial to thwart aggressive gerrymanders. Third, speaking of that partisan fairness criterion, the current version of H.R.1 really emphasizes the durability of a plan's partisan bias. And durability is obviously important, but just as important is the severity or the magnitude of a plan's bias. We should still be quite concerned about plans that are highly biased, even if that bias isn't all that persistent over time. And so I think the subsection of H.R.1 that explains how the partisan fairness criterion would be implemented ought to emphasize whether a plan results in durable or severe partisan bias, not just whether it results in a durable bias. Fourth, I've heard people worry that if Congress requires states to use redistricting commissions, that would amount to unconstitutional commandeering. Now, I think this argument is weak because Congress has the power to commandeer when it legislates under the Elections Clause. But to negate this issue altogether, what I think Congress should do is give states a choice. So either set up your own commission, as H.R.1 currently specifies, or the federal government will set up a commission for you without requiring the states themselves to lift a finger. Notably, that's exactly what Congress did under Obamacare with the exchanges for health insurance plans. It gave states the option of either setting up the exchanges themselves or letting the federal government do it for them. And that offer of a choice by Congress totally prevented any anti-commandeering challenge to Obamacare from ever getting off the ground. It may have been the only argument against Obamacare that never got off the ground in the courts. Fifth, and now we're getting into more ambitious, maybe less realistic territory. I would apply all of H.R.1's redistricting provisions to state legislatures, not just to congressional delegations. So state legislative gerrymandering is at least as urgent and as troublesome of a problem as congressional gerrymandering. And so I don't think Congress should allow the states to keep distorting and manipulating district for partisan advantage. Note that Congress can't use the Elections Clause to regulate state legislative as opposed to federal elections. But it can use the Republican Guarantee Clause, since gerrymandering is maybe the classic example of an anti-Republican, anti-democratic practice. And Congress can also invoke its enforcement power under the 14th Amendment, since even the Roberts Court agrees that severe partisan gerrymandering is unconstitutional, even if it's not actually justiciable in the courts. Okay, and last thing, I would also like to see Congress open the door to electoral arrangements other than single member districts. For example, multi-member districts with preferential voting, or mixed member proportional representation like they have in New Zealand or Germany. The easiest way to do this would just be to strike a single word from H.R.1. This is the word single member, the phrase single member in the sentence in H.R.1 that requires each congressional plan to be made up of, quote, single member congressional districts. If that one term was stricken, then states could experiment with different kinds of electoral systems. And several of those, like the ones I mentioned a minute ago, would do a better job of ensuring partisan fairness than even the least gerrymandered single member district plan. And several of those alternatives would also lead to better representation for all kinds of minorities, racial minorities, ideological minorities, and so on. And they might even lead to less legislative polarization, and thereby tackle another serious problem in our current democratic. So that'll stop. There's a lot on the table there, and I look forward to people's questions and comments down the road. Thanks.
Thank you so much, Nick. And we will conclude with Ben Ginsburg.
Thank you. Good afternoon, and I appreciate being invited to this session and all the sessions, which have really been fascinating on H.R.1. I think that my contribution here can really be to give you some idea of the way I think this bill, and specifically the redistricting provisions, will be greeted on Capitol Hill, where, of course, things are a lot tighter in terms of the lineup of Republicans and Democrats than perhaps people thought in 2019 and even 2020. And one thing that I would say as a general matter about H.R.1 and the redistricting provisions in particular is that what is clear is the sincerity of the people who are proposing this. And the presentations today have been a great example of that. And in fact, the bill does have some provisions that I suspect can gather bipartisan support and passage. But honestly, I appreciate the sincerity, but the sum total of the bill, and especially the redistricting provisions, seems rather than a reform effort that the wily political operatives from the Democratic Party got a hold of the provisions. Because I think what Republicans will view when the bill is actually moved on Capitol Hill is a real partisan power play designed to reverse a couple decades of electoral results that took place. I also think that the bill, if it is introduced at any point this year, will be introduced in obviously a highly partisan atmosphere, but at a time that the Republican Party is succeeding in basically destroying itself from either wings. And I think what is absolutely true is that this is a bill that will unite the disintegrating factions of the Republican Party really quickly. And the redistricting provisions are no exception to that. And to the extent the Biden administration hopes for a bipartisan approach to any number of bills, ranging from COVID relief to economic stimulus to infrastructure to Iran, this will be something that will make a bipartisan approach to much of anything really much more difficult, because the Republicans on the Hill are going to see this as a direct attempt to shape a system for partisan advantage. I think on the redistricting provisions in particular, the arguments that you'll hear will be about federalism, although you would be right to be a tad skeptical about Republicans arguing federalism after the Electoral College lawsuits and votes. But nonetheless, that will be the argument. They will say that one size does not fit all in the the general overall area of what happens in states regarding elections, including redistricting. I think they'll say there's a certain Rube Goldberg-esque quality to the provisions of this bill and how it all gets put together. Unfunded mandates will come up, although I understand that there are attempts in the bill to be able to argue that there aren't unfunded mandates. I'm not sure they all entirely work. It's also not clear from the bill, I think, if the goal is to create competitive districts or ungerrymandered districts or outright compact districts. And the whole provisions in the redistricting portions of the bill, I think deserve discussion in the context of the 50-year demographic trends, the big sort in Bill Bishop's phrase, that have led us to live in communities that are much more homogeneous, and how that plays into the way these bills come about. I think it's also in terms of the redistricting commissions in particular will run into considerable opposition from the fact that they take away local officials' control and input into their own bills. And you have 15 individuals for your commissions. Again, there'll be a one-size-fits-all argument about that. But the difficulty with redistricting commissions is not only the makeup of who the commissioners are, but also the staff involved. And in a number of states, the staff ends up being tilted to one party or another. And there are no provisions to take care of that, although the staff may be the most important component of a citizen redistricting commission. Overall, there are provisions in this and the redistricting parts that I think certainly Republicans would embrace. The transparency parts, I appreciate that there are some states that are not terribly transparent in their redistricting process, but many certainly are. And the notion of an expedited right of action to be able to deal with infirmities in the bill is one that I think gets universal approval as well. I think it's also worth noting that this bill comes in the context of a 2020 election where Republicans have 13 more members in the US House of Representatives than they did in 2019, that Republicans have a 50-50 split in the Senate. It's not the 52 to 55 seats Democrats envisioned a couple of cycles ago. And in fact, Republicans, although losing the White House and the Senate, did manage to do well from their point of view in state legislative races. So that while Republicans may control the lines in 180 or so districts as compared to the Democrats, remember that to have that control, they also have to win the governorship. And so the governorship is not subject to redistricting manipulation. So perhaps it's an expression of the actual strength in the case. So the idea of redistricting commissions and these provisions in H.R.1 will generally be viewed by Republicans on the Hill as a way to circumscribe and try and fix what Democrats believe were unfortunate results in the last 2 decades worth of elections, really. And so this will be seen as a highly partisan bill. You can cloak it in as much reform language as you want, but the political realities will be the political realities. And lastly, I guess I'd say that if this bill is actually pushed in this Congress, as opposed to merely being introduced, but pushed, it'll be a huge gift, unintended as that may be, to the Republican Party as it goes to war with itself and is really destroying itself. But this bill and its provisions, no matter what the intentions behind the provisions are, will, I think, have the effect of unifying the Republican Party.
Wonderful. So let me offer a few thoughts of my own, and then let me open it up to questions for folks. Let me talk a little bit as someone who often gets appointed to draw districts in my role as a special master or court-appointed expert, and how principles like this would be implemented and how challenging they are. Let me just start with a prefatory remark on redistricting commissions generally, which is that, and Ruth mentioned both Arizona and California. I will say that no one has arrived at an institutional option which is widely agreed by virtue of its structure to be nonpartisan. And by that, I mean that if you look at Arizona, which was held out as the sort of paragon of nonpartisan redistricting in the 2000 round, in the 2010 round, the nonpartisan appointee, sort of chair of the commission, was then impeached, right, and removed by the state Senate and then reinstated by the state Supreme Court because, in particular, Republicans thought that she was too biased in favor of the Democrats. Similarly, I think in California, and I think it's right that this is largely modeled on what we have here in California, Republicans felt that the commission, that basically Democrats played the commission last time. And while I actually think that the California Commission did a very good job last time, I was I wouldn't say a vocal critic, but I was suspicious about how well they would do. I thought they did a surprisingly good job last time. Nevertheless, it sometimes takes a cycle for partisan interest groups to understand how these commissions work and how they can try to game the system a little bit. So I don't want to sort of cast shade on all redistricting commission attempts. I think that is the future and the way to go, and I think we need a lot of experimentation in this area. But that, one of the difficulties often is that these folks are either appointed or they're elected, and we're living in a world in which everyone's proclivities are being interrogated. I of course live that whenever I get appointed to do these cases. So that's just on the institutional side. Let me say a little bit about the principles themselves. I want to agree with Nick on one thing, which is that I would hope that if there is some kind of reform that gets pushed through in the redistricting realm, that it does open up the possibility, it does give permission, at least for congressional delegations to be elected through alternative districting arrangements, whether it's proportional representation, which I favor, or some other kind of alternative voting system. At a minimum, states should have the latitude to do so. And right now they don't because of the single member district requirement. I think as we sort of go further down this line, I think that those kind of creative solutions should definitely be on the table. Lee Drutman has a long sort of article and book on this. But let me talk about how you draw lines and how you try to square the circle between communities of interest and partisanship on the other hand, right? And so on the one hand, with this bill, I kind of want to see it pass because I do think it will be a full employment bill for election lawyers, and who could be against that? And so I think that if you are someone who is drawing the lines, you could see in the bill plenty of possibilities for people to try to knock it down. And you see this whenever these kinds of laws are passed at the state level, whether it's with respect to too much partisanship on the one hand, or inattentiveness to communities of interest on the other. You could easily see that a lot of these partisan interest group concerns will then be re-articulated as community of interest concerns. And you see that was part of the argument the Republicans made against the Democrats' lobbying of the California Redistricting Commission. I'll say that one thing that Nick has pointed out before, and I think is true, is that we will have to have some kind of accepted position on what data and what measures are going to be used to identify partisan bias. Of course, Nick was a pioneer in thinking about like the efficiency gap and some other measures. And so I don't think we get out of part of some of the questions that were raised in the Rucho case from a year or two ago with this bill, but it does put us on the pathway to developing what would be a kind of federal standard for partisan gerrymandering. So mainly, I just sort of had those thoughts, but I'll now just turn to questions. Maybe we'll start with Ben's question, but Ben's sort of point here. And I mean, Ruth, you talked about why both Republicans and Democrats should like this bill. Ben explains what I think is the realpolitik of all of this, which is that this is coming in at a point where this will be seen as taking away seats from Republicans. Is that not a fair characterization?
To the extent that in order to pass, it only needs Democratic votes, I'm going to send Ben's quote to every Democrat I know and explain to them that maybe this would be great for their party. I don't happen to agree that in the long term it will be beneficial to one party versus the other. But if there are swing state senators out there that want to be great Americans and do this regardless of the reason, then I'm all for it. I mean, I think in a temporal sense, both sides will get advantage over the many years, but perhaps in this decade, we will see more advantage for Republicans if they're allowed to gerrymander.
Michael, do you want to chime in on that critique?
Yeah, I mean, I do. I agree with what Ruth said. I mean, I do think like you have to think about like gerrymandering at multiple levels, right? I mean, there is like, you know, where you try to like maximize the number of seats for your party, but then there's also sort of like a very individual level, right? And like this process in many states is very secretive. It is controlled by interest, not always the members, right? You know, and Ruth gave a perfect example, legislative example, but in Wisconsin, members got to see their own district. They didn't get to see the whole of the map, right? They got to see their own district because leadership was controlling all of this, right? And so in other states, again, this is perhaps more at the legislative level, but, you know, like people are punished or rewarded by leadership, by their own party, right? And that is a consideration that I think you have to think about, like, you know, so it's not always just D's versus R's. There's also like a intra-party aspect that sometimes goes there. And, you know, I think to your point about like commissions, I mean, the one thing that we saw like is, like whatever, however well this commission does, or these commissions do, like they will not do worse than legislatures, right? And that is the key thing. And like even flawed commissions, even like in New Jersey, which is not a very great commission, right? It has a tie-breaking member, the tie-breaking member goes for one side or the other, you win everything, right? But even that, like the maps produced by even flawed commissions are not nearly as politically skewed as maps drawn by state legislatures, right? And so that's a key thing, I think, to just be sure to remember there.
Yeah, no, I think I agree with that. Nick, on this question of measuring partisan bias, I referenced your work on this. Where do you think so suppose this gets passed, what do you think is going to be the rule of that measuring partisan bias in these redistricting plans?
So I think the bill invites, I think, a sort of inclusive Catholic attitude toward different measures and different technologies. I imagine that a commission would want to consider multiple different measures of partisan fairness. My own, the traditional political scientists' measure of partisan asymmetry. They probably want to use computer algorithms and compare enacted plans or potential plans to the distribution of simulated maps. I think they would likely consider the set of those measures and look for a clear signal in all of those different approaches. That's what courts did, in the Rucho litigation at the lower before the Supreme Court, and I think that's the model that this bill points us toward. Let me just add one quick thing also about the partisanship or bipartisanship here. I think a bill like H.R.1 could be bipartisan in the same sense that the Democrats' current COVID relief proposal is bipartisan. Every single Republican will probably vote against the current COVID relief package, but among the public, supermajorities of Democrats and independents and lots of Republicans support the COVID relief plan. And from the polling that I've seen on something like H.R.1, it's the exact same picture, where ordinary, non-elite, non-elected Republicans are strongly in support, or many of them are, in favor of measures that improve our democracy. And so in that sense, I think a bill like H.R.1 could be genuinely bipartisan.
Ben, can you talk a little bit about what redistricting reform, if any, should be at the federal level? We got some questions in chat that if not this, look, you've got the bruises to prove it from 30 years of redistricting litigation or however much. What is there something at the federal level that should be done if not this?
I can't imagine something on the federal level being acceptable to Republicans. I think the antipathy towards the one size fits all notion would be very difficult. I mean, it might be something which I guess will be an extremely relevant topic in the next 24 hours, is what you do about the census to get uniform and reliable data to all the states. That's something that I think could be done on the federal level.
I realized on Twitter, I promised I would talk a little bit about this. The census has said that that the data will not be made available to the states for redistricting until the summer at the earliest. And so I've been getting plenty of questions about what this means. Virginia and New Jersey that have to redraw their lines for the upcoming election are going to be in quite a bind to get those districts done in time. Many of them, they maybe will not even get their redistricting plans done then. That's true also for some local elections. I'm currently drawing districts for a certain local race that has to be done in the fall. This will probably they'll have to be drawn based on the old census numbers. And so there's been a lot of changes, of course, with the census because of change in administration, but also how difficult it was to run the census because of COVID. And so it's pushed back the normal calendar here for the contemporary districting cycle. And so we should expect that, the fall and fall and winter of the next 12 months to be extremely active when it comes to redistricting. With that, I'll turn it over to Dee Dee, who can mine some of the questions in the Q&A.
Okay, so we're getting a lot of different categories of questions, but the first I think picks up on some of Ben's criticism. So I'd open this to the rest of the panelists. What kinds of constitutional opposition or what legal arguments do you see opponents of H.R.1 making if H.R.1 passes, and how likely is the bill to withstand that scrutiny? Michael, we can start with you.
Well, we know that Amy Coney Barrett would have no opinion on this until she had a chance to hear argument, read the briefs, and consult with colleagues, as she repeatedly said during her confirmation hearing. No, I think what Nick mentioned, one of the things that I think people will raise is this commandeering argument, the idea that you're telling states to do something that's for the federal government. Now, I think there's a lot of case law. The National Voter Registration Act was challenged on commandeering grounds and survived. And so I think there's a lot of precedent that says that Congress, when exercising its election clause powers, can do exactly this. But of course, we are in a world with a different court. And I think I do agree with Nick that, it would be good to sort of build in some safeguards, right? If it somehow doesn't, then, maybe something kicks in, but it also probably merits separating out the criteria so that it clearly applies to whoever draws the maps. A state shall enact a redistricting plan using these criteria, and without, I think right now you may say the independent commission of a state shall, right? So you want to at least make that severable, and that's I think that's probably the commandeering one is probably the biggest one that I see on the horizon, but that's also, as we've learned from 2020, there are no shortage of relatively or very frivolous arguments that people are willing to make and try to see what sticks.
Ruth?
I wanted to add in one thing, Didi, that one of the changes that happened with the H.R.1 for this year, as opposed to the H.R.1 from 2019, was to invoke as constitutional authority for the bill the guarantee clause, which is famously non-justiciable. So to the extent that I get to do another case before John Roberts and friends, I'm very happy to explain to him that he should not be overturning this bill because it is in fact non-justiciable.
Ben, Nick, any other thoughts?
But I would just add, people don't fully appreciate, I think, in the legal community, just how vast Congress's power is over federal elections under the Elections Clause. And that's because historically, Congress has never exercised anything close to the full breadth of power that it has under this provision. But numerous justices, conservative justices like Justice Scalia, quite recently, have said that under the Elections Clause, Congress essentially has plenary authority over federal elections. It hasn't used that, but it could. And so I think the way to see the redistricting provisions of H.R.1 is as a first tentative step by Congress toward fully exploiting the power that it does possess over federal elections.
So do you feel then that the error with the Voting Rights Act was that they didn't really lean on that clause as heavily as Section 2 of the 15th Amendment? That if they moved it, if they had more on the Elections Clause in the preamble or something like that, that then the court would have upheld Section 5 of the Voting Rights Act?
No, because so much of the VRA goes beyond federal elections. Like if the VRA purported to only regulate federal elections, then sure, I think that anti-retrogression, all of Section 5's apparatus would be fine. But because it applied to elections at all levels, it couldn't be justified to that extent under the Elections Clause.
So this is a process point about the bill, I suppose. If it passes Congress in this session, but it doesn't go into effect until 2031, could a future GOP Congress just enact new statutory provisions to overturn H.R.1? Nick is nodding. Nick, you want to go ahead?
I mean, absolutely. Even if it does go into effect for 2021 or 2022, through whatever process it's enacted, it could also be rescinded in the future. That's true of any legislation. I think it would be popular legislation. I think that once enacted, there would be inertia and entrenchment of these provisions. But of course, it could be undone in the future.
Right. It would also depend a little on, in terms of the way it got enacted, if there was some small edit to the filibuster, if it was a one-time democracy exception, that might be easier to undo. If it was a 1 mega bill per year, maybe, a GOP legislature couldn't include that. So it's not 100% clear that would happen as a political matter, but I agree with Nick, legally it could.
I think if this bill were actually to get signed into law, you would see a variety of novel charges against the bill, and you would see an attempt in Congress to at least amend parts of it.
So I agree with all of that, it's just with the caveat that if the commissions actually do come into effect and draw maps somehow this decade, the proof of concept, I think, will give people greater comfort, right? In California, a bunch of the seats that Democrats won in 2018 were in places like Orange County, but those were exactly the places where Republicans re-won seats this decade, right? Or this election. And so, the idea that, map swing is the mood of the people swings is a great, thing. And, people, I think, kind of perhaps might feel a little bit more comfortable. Having said that, it might be difficult to get the commissions to fit into 2021, just given the timeline. So.
Right. Okay, so there's a set of questions about the Voting Rights Act provisions and their interactions with H.R.1. To what extent does H.R.1 strengthen various voting rights protections and how does it differ from provisions that have been in previous legislation or struck down by the Supreme Court or upheld? I suppose we can start with Michael.
Yeah, that's a great question because we've talked a lot about partisanship, but it bears mentioning that H.R.1 is at its heart very much a racial justice measure, right? And one that responds to the increasingly complicated America that we live in. Right now, half of all Black Americans, half of all Latino Americans, half of all Asian Americans, each group separately, who live in metro areas now live in the suburbs rather than in the urban cores. And those are places where traditionally the voting rights remedies are hard to exercise, right? You can't draw these majority minority districts. I mean, what H.R.1 does is it provides enhanced protection for coalition districts, where the multiracial coalitions of the future, where you saw people win in the suburbs of Georgia or being very competitive in the suburbs of Dallas or Houston. And it also provides protection for communities of color, which particularly for groups like Asian, or not communities of color, communities of interest, provides protection for communities of interest, which for communities of color like Asians is critical because Asians rarely have sort of the mass, even in the urban cores, to create single racial minority districts, but as a result are oftentimes badly fractured among multiple districts. Instead, if you keep Asian communities together, you'll find that Asian communities, while they may not determine the outcome of the election, have a huge impact on influencing the election. And so H.R.1 really is at its core really very much a racial justice measure and important for the more complicated, more diverse America of the future, the multiracial America of the future.
Anyone else?
I would add that I think that on policy terms, I completely agree with Michael. I would note that for critics of H.R.1, all those benefits that Michael talked about might also be fodder for a legal challenge. The racial representation components of H.R.1 amount to a recognition that so-called crossover districts would be protected under federal law. In a case about 10 or 15 years ago, the Supreme Court said that if federal law required the creation of crossover districts, that might result in constitutional concerns. And so I think this language in H.R.1 could potentially raise those constitutional concerns. I don't think it's blatantly unconstitutional, but it at least presents a colorable constitutional issue.
I do think that some of the language could be tweaked a bit, right, to sort of address some of those concerns, because I recognize that again, like there will be lots of litigation over this, and it's important to get it right. But the principle, at least, is that we need to protect minority political power outside of majority minority districts, because increasingly that's where people of color live.
Didi, could I ask a question that I'm curious about? Will this bill be subject to amendment in the minds of the managers, or is it a take it or leave it piece of legislation?
There will almost certainly be a manager's amendment and perhaps other amendments.
But what about floor amendments?
I don't know. I don't know. They haven't come up with a rule yet for that, but there were a number of amendments the last time.
No, but do you all as the sponsors encourage amendments to this, or is it a take it or leave it piece of legislation?
Well, I can't speak as a member.
If it's take it or leave it, I'd take it. But as long as they want to talk about amendments, we can look at them.
Yeah, I do think like they're, people have amendments to make, and I suspect like Iowa was carved out in the last go round on redistricting, right? There were the independent commissions that exist right now in states like California are carved out from H.R.1. The people in Iowa wanted Iowa also carved out, and people agreed to that. And I think there were a couple of other tweaks, and so I suspect there will be lots of amendments. But I don't think that this is the end all be all, but there at least will be a manager's amendment and perhaps others, but I don't have any inside information on the others part of that. So.
Well, let me just say that apropos Ben's question, which is that is in some ways the critical question over the next few months. And it's not, and this leaves the redistricting provision aside, will the bill be split up into its component parts and considered, because if the, on some of the election administration provisions, for example, funding for election administration, will that garner bipartisan support? But as Michael, I think, was saying, was it Michael who was saying this, that the just like with COVID relief or other kinds of omnibus legislation, there's always the possibility you could split it up into its bipartisan components and the ones that are more supported by the Democrats. But I think that, part of the point here is to have a big reform of American democracy. And that, yes, some of the details will be worked out later, but that also there'll be some that'll be worked up in courts, right, over time. But I do think, Ben, that is the $1 million question here, because I think if it gets split up and into its component parts, that it's likely the election administration, not even the election administration writ large, but some of the individual aspects of the bill are the ones that are most likely to get passed. And then you have something that's more like the NVRA or HAVA that comes out, as opposed to a kind of bold statement, you know, on democratic reform. But you know, that's the old mold, you know, as to whether they're going to try to compromise and get something that is bipartisan through.
Yeah. I mean, Nancy Pelosi right now, at least, is being very stubborn on it not being split apart. I do think the redistricting piece, because of the timing consideration,
Yeah,
may move differently. I mean, you know, the other pieces don't really matter till later, but redistricting is going to have to take place soon.
So we're getting a lot of questions asking what a fair map will look like under H.R.1. I know you've been clear that it's not about districts, it's about states, but this involves, I think, going into a little more detail about the measures of partisan bias that the bill is assuming, and also the criteria for map drawing that the bill specifies. What would a fair drawing look like, and how would it be determined? Michael, I guess you had already started to go into detail about some of this, but if you can elaborate.
I think there's going to be an amendment to allow Nate to draw all the country's maps, and that will result in like perfectly fair maps. You know, and we'll just create a computer Nate for when Nate is no longer with us. No, I think, you know, the reality is, like last decade, you know, courts found it really easy to find the outliers, right? You know, both state courts and federal courts, and the only court that seemed to have trouble with it was the Supreme Court, and it was, you know, like certain justices on the Supreme Court, right? You know, lower courts had no problem, like, you know, applying these rules and striking down the outliers. Now, which is not to say that there won't be gray area cases that are harder in the future. You know, last decade's gerrymanders were quite extreme, but you know, even if you just sort of policed, you know, the 13-5 gerrymander in Pennsylvania, the 10-3 gerrymander in North Carolina, you know, 12-4 in Ohio. I mean, you're getting a long way to having politically fairer maps, and again, racially fairer maps, right? Because like the reality is, you don't successfully do a gerrymander in much of the country, especially the South, without targeting communities of color, right? There just aren't enough white Democrats in the South, and they tend to live really close to white Republicans in the South, sometimes in the same house. And so you have to go down and draw a line down somebody's bed to gerrymander white Democrats in the South. And so it's much easier to target communities of color. And, you know, so, you know, again, but there's a wide range of measures. It's evolving. You know, I think a lot of it's very exciting, but perhaps Nick could speak more about that, because it's a really cool area. Like, we're getting a lot of new stuff.
Yeah, I would say a couple of things, right? So H.R.1 recognizes that there are a whole array of valid redistricting objectives, providing representation to racial minority members, respecting communities of interest of all kinds, respecting political subdivision boundaries, and ensuring plan-wide partisan fairness. That would seem to be a problem when you have, you know, 3 or 4 or 5 considerations, which might not all point in the same direction. But the other really interesting thing is that there are effectively infinite district maps available for any jurisdiction. And so in most cases, there are maps that either an expert human line drawer like Nate or a computer can find that do a pretty good job along essentially every dimension. So I've been playing a lot recently with computer simulated redistricting maps. And it turns out that, you know, virtually everywhere you can improve on the status quo map on basically every dimension you care about. You can do a better job respecting county boundaries. You can provide more minority opportunity districts. You can lower the partisan bias of the map, all at the same time. You know, we're starting from such a low baseline with gerrymandered maps in many states around the country that simultaneous improvement on lots and lots of dimensions typically is possible.
Okay. Oh, Nate.
Yeah, let me just chime in on that, because just to reveal some of my thinking when I do maps, which is that beating all the proposals is kind of a nice lodestar for me, you know, in a lot of this litigation. And so I think Nick is right. Now, since I only work for courts, though, the challenge, there's a huge difference between any plan that factors in incumbency and those that don't, right? And so that's going to be one of the key questions that these commissions are going to have to deal with, because that's one of, and when I say incumbency, I don't just mean unpairing incumbents, right? But it's all the idiosyncrasies that dominate an incumbent led process, and how that might affect where districts are drawn. And while it's popular to say, oh, well, keep the incumbents out of the process, don't consider all this stuff. Well, that's one of the ways that you can end up having partisan disadvantage, right? Is if a plan ignores incumbents and then disproportionately impacts one or more. And I've drawn plans like that where there was a disparate impact because the court ordered me not to look at incumbent residents at all. And so that's the thing that the algorithms never can quite capture, is thinking about those unique factors. Now, maybe that's a good thing because, oh my God, it's like, why do we have to consider, where that the incumbent wants to have, the gravesite of her mother in her district, right? It's like that might not be something that we really want to have as part of a healthy redistricting process. Or another case, the private school where the incumbent's kid goes, they want to have that school in the district, right? It's like, all right. But as you start peeling away, there are times when drawn districts where it ends up having this disparate impact on incumbents, and then things get a little bit hairy. I think that it may be that what will happen, I mean, if it happens like the California redistricting process, that one of the great benefits of those commission-led systems is that they force people to articulate incumbency-related concerns in non-crazy ways, right? So that you end up with sort of more transparent reflections of what the kind of considerations might be for a particular redistricting process. That is also, I think, Ben, in thinking about the opportunities for bipartisan movement here, as you were saying, like transparency before, that might be something that even at the federal level, a federal requirement on transparency might be something that could get through. And I think a lot could be gained by that. A lot, forcing people to explain why they are doing one thing versus another sometimes can have a sanitizing effect on the redistricting process.
Okay, so in our final 3 minutes, there's just a question about if a map is found in violation of H.R.1. Ruth, you had mentioned in your talk that the bill arms you, litigators, with any number of arguments to use in court. What exactly is the remedy, or sort of what is the process for deciding if a state map is in violation, and then what happens next, Ruth?
So as it's currently drafted, you would go to a federal district court and you'd be challenging it's a statewide congressional plan. So you get a 3-member court with direct appeal to the US Supreme Court. And say you manage to strike it down and you said, this is in violation. The usual process is deference to the line drawers. And so what the court would say is, Commission, you need to go back and draw a new plan in light of the fact that we've said that this is the reason why the current plan is problematic. Now, sometimes plaintiffs in that space can say, well, yes, the commission has said this is their remedy, but it's problematic in all these ways. And so sometimes courts can get involved, but usually that would be the process. It wouldn't be that a plaintiff can just sue and get whatever they want. Usually they can get rid of things that are illegal, but the independent commission, the People's Commission, would still have the chance to do something legal.
Okay, anyone else? Nick or Michael? Ben?
I think, like this is like the remedy, I think, is one area where people have suggested perhaps beefing up H.R.1 to, where courts oftentimes strike down maps, but then somehow it gets like boggled in the appellate process. So, or, maps get sent back to the state legislature to draw, and, there might be a streamlining of that process, because that is, again, just judicial convention. It is not, necessarily something that is required by law. And so giving the court the power to, enact an interim plan and things like that, which is provided in the situation where there's deadlock, but, moving some of those provisions and also making them applicable to challenges, might be something that could bolster this and change some of the power dynamics, right? Because like sometimes litigation is a goal of, like tying things up in the court is the goal of the party that drew the map, and like changing the power dynamics a bit is something that might be worth looking into.
I say one thing
I
also
will-
here, which I said one quick thing, which is that the hope I think under H.R.1 would be that there is far, far less redistricting litigation than there currently is. Once maps are drawn pursuant to good government criteria by relatively objective bodies like commissions, there ought to be much less serious grievances by any actor or party with the output of the commission. This has been somewhat true at the state level, where commission-drawn plans have quite rarely been struck down by the courts. And it's been completely true abroad, where the movement towards depoliticizing redistricting has also gone hand in hand with de-judicializing redistricting. So I would hope that H.R.1 would be the start of a new era in American redistricting, where the courts are not dragged into every single redistricting plan, and where by and large, the maps drawn by the commissions are the maps we get.
All right, well, we are out of time. We are a little bit over, but thank you everyone for joining us today. Thank you to our panelists for this incredibly clear explanation of the redistricting provisions of H.R.1 and the political battles it may or may not face. Tomorrow, we will be having our final H.R.1 webinar on the topic of campaign finance. So please join us if you can. And again, all of these sessions will be recorded and maintained online, along with further resources for those interested in following the bill. Thank you so much, everyone, and have a great day.